to the subject matter is a concept developed by the Court of Justice of European Union and is applicable in the European public procurement law. While it is a strictly European invention, its premise will be equally applicable in various global contexts. The logic behind the concept of a link to the subject matter is that the buyer should not become distracted and focus on other elements that have little or nothing to do with the subject matter of what they are buying. Therefore, a winner of a bid should be chosen based on various considerations, specifically focused on and related to what the public buyer is purchasing. The link to the subject matter represents a safeguard against protectionism and the abuse of sustainable consideration, such as greenwashing. It also reinforced the commercial and economic focus of the notion that European Union public procurement law is a part of international economic law and aims towards open competition and liberalization of the international trade beyond anything else. The concept has been developed by the Court of the European Union, as I mentioned before, specifically in a Concordia case, a case that has been considered a cornerstone of the European case law concerning sustainable public procurement. So what were the facts of the case? Helsinki City decided to renew the contract to outsource the city's public transport services. The contract to be awarded according to the most economically advantageous tender criteria. Well, indeed endowed with 3 sets of supplementary criteria: the overall price of the operation, the quality of vehicles, the quantity of nitrogen oxide emissions and external noise. One of the companies, Concordia, has been refused being considered not complying with the aforementioned requirements. However, Concordia proposed the lowest price tender and it scored high points in other non-environmental requirements. Concordia claimed that the award criteria pursuing environmental policies were invalid and discriminatory, therefore not in compliance with European Union public procurement law. The court confirmed that it is allowed to include environmental consideration in public procurement. However, they must conform with EU law and do not hamper competition. The court established 4 conditions for the inclusion of environmental consideration in EU public procurement. Those considerations must be expressly mentioned in the contract notice. They must be non-discriminatory, suitable for objective evaluation, and linked to the subject matter of the contract. In the case at hand, the court found that the emissions level could be regarded both as criteria related to the subject matter of the contract and also suitable for objective evaluation. It is worth underlining that while the case relates solely to environmental consideration, the same 4 requirements are applicable when the buyer would like to include social considerations in public procurement process. Concordia has been followed by EVN Wienström case, where the Court of Justice of European Union concluded that consideration regarding renewable energy were not linked to the subject matter due to the design of the tender. The contracting authority in that case, amongst other issues, was to consider supply's overall capacity to deliver electricity from renewable sources, instead of specific quantities that it was to buy, which proved to be not linked to the subject matter. This notion is reinforced in today's EU Public Procurement Directive, so-called Classic Directive, in Recital 97, which prohibits contracting authorities from applying a general corporate social or environmental responsibility policy within the public procurement process. As an example of such prohibited factors that cannot be considered in the procurement process, we can mention asking for overall production's capacity of renewable energy or considering company diversity hiring policy. Since then, the concept has been further developed and ultimately codified in public procurement directives. First, the link to the subject matter found its way as a requirement for an award criteria in the 2004 directives. Since then, the application of the concept has spread out. Today, it is applicable concerning technical specifications, labels, variants, selection criteria, award criteria, as well as contract performance clauses in the 2014 directives. So what is meant by link to the subject matter of the contract? Article 67, para 3 of the Directive 2014-24 reflects that social and environmental aspects shall be considered to be linked to the subject matter of public contract where they relate to work supplies or services to be provided under that contract in any respect at any stage of the life cycle. The current directive also clarifies concept following from the so-called Dutch coffee case. In the case, the court established that the concept of the link to the subject matter of the contract includes so-called immaterial aspects. These immaterial aspects are involved in, for example, production process, provision of trading of those works, supplies or services, or a specific process for another stage of their life cycle, such as recyclability. An example of immaterial factors can be given of an organic agriculture. Even though the final product on the market may be the same, the factors still can play a role in the competitive setting of public procurement. This has been illustrated by a famous statement made by Advocate General Cocker when she wrote, "Of course, the taste of sugar does not vary depending on whether it was traded fairly or unfairly. A product placed on the market on unfair condition does, however, leave a bitter taste in mouth of a socially responsible customer." End of quote. To conclude, the concept of a link to the subject matter of the contract is crucial if you want to pursue sustainable public procurement, as this concept of link to the subject matter provides the limitation on what the buyer can lawfully consider in public procurement process. It has been often criticized as limiting the contracting authority's discretion in buying sustainably and contributing to creating a sustainable public contract market. At the same time, the concept has been seen, as mentioned before, as a safeguard from including irrelevant or non-measurable factors that are solely a type of greenwashing or smokescreen for protectionist behavior.